Guys, we'll be studying general defenses right now. One of the most important prospect of general defenses is voluntary non-fit injuria because वीएनएफआई से ना बहुत सारे प्रीवियस ईयर क्वेश्चंस भी आ रखे हैं, लेकिन इन जनरली आपके यूनिवर्सिटी लेवल एग्जाम्स में भी पांचों छह चीजें पूछेंगे. तो मेजरली वी हैव सेकंड वीएनएफआई वीएनएफआई इनएविटेबल एक्सीडेंट एक्सीडेंट नेसेसिटी नेसेसिटी विस मेजर एंड लास्टली स्टैट्यूटरी अथॉरिटी स्टैट्यूटरी अथॉरिटी. ठीक है, ये इंपॉर्टेंट है. और वीएनएफए समझते हैं क्या होता है. सबसे पहले अंडर वॉलंटरी नॉन फूड इंजरिया नो मैन कैन enforce a right which he has voluntarily waived in favor of the another. Voluntary waived in favor of the another. The maximum applies in two cases. First is what? Intentional acts which would otherwise be tortious. Second, consent to run the risk of accidents. Right. वीएनएफआई का मैं आपको सिंपल सा एक एक्सप्लेनेशन और दे देता हूँ यहाँ पर. To a willing person, no injury happens. To a willing person, no injury happens. That is the same. ठीक है. Only exception is where the act causing the harm must not go beyond what had been consented to. ठीक है. Next, there is the case of Hall versus Brooklands case racing club. Due to a collision between two cars, one of them was thrown in the stands, thereby injuring the plaintiff. No such action had occurred in the past. It was held that the plaintiff impliedly consented to run the risk of such an inquiry, the danger being inherent in the sport which a spectator could eventually foresee. Important landmark judgment. Then there is the case of Murphy versus Steeplechase Amusement Company. Plaintiff got injured in one of the amusement parks. It was held that one who takes part in such sport accepts the dangers inherent in it, so far as they're obvious and foreseeable. Right? If something has to be pleaded under the concept of voluntary non-fit injuria, इसमें सबसे पहले क्या होगा? That the plaintiff is holding full knowledge of the act. वीएनएफआई में. ठीक है. First is full knowledge of the act. Second, plaintiff had consented to the risk involved. Consent to the risk which is involved. ठीक है. Essential conditions of voluntary non-fit injuria क्या है? First of all, there is the concept of free consent. Consent must be free. Plus, the act done by the defendant should be the same act which is consented to. Second, no VNFI when a servant is compelled to do some work despite his protests. Then, what is knowledge? To avail the defense of VNFI, it is necessary to first show that the plaintiff was aware of the risk, and second, that he knowingly accepted it. वही consent का scene. Mere scientai is not enough. There should be an appreciation and acceptance of the risk which is involved. Smith versus Charles Baker and Sons का एक केस है, which is also known as the Stone Quarry case. Mere knowledge of the risk without assumption of it does not help applying VNFI. It must be shown that the nature of risk was brought to the mind of the person and that the accident to him arise from a danger foreseen as well as appreciated by him. Right? वही है, नो साइंटी का कॉन्सेप्ट हमें ध्यान रखना है. राइट. mere knowledge of risk is not enough, and it is absolutely incorrect to state that no injury is done to one who knowingly does an act. Very important to know that. Then South Indian Industries versus Alamelu Amal का एक केस है that the plaintiff had some knowledge of danger is not sufficient. A man cannot voluntarily undertake a risk, the extent of which he does not appreciate. ठीक है. लॉट वर्सेस विल्क्स का एक केस था. A trespasser knowing about the presence of spring guns on the land could not recover damages when he was shot by spring gun. सिंपल सा केस है. अब सारे देखो, आपको याद तो नहीं रहने वाले हैं. कुछ कुछ जो मेन मेन है वो याद रखना. हॉल वर्सेस बुकलैंड्स का हो गया, मर्फी का हो गया, और स्टोन क्वारी केस हो गया. एक इंडियन कर लेना. चार तो पढ़ना ही पड़ेंगे देखो, अगर इफ यू वांट टू एक्सेल, राइट. देन एक्सेप्शंस क्या है वीएनएफआई के? फर्स्ट, इलीगल कंसेंट है बाय फ्रॉड और ड्यूरेस. लेकिन ब्रीच ऑफ स्टैट्यूटरी ड्यूटी करी है किसी ने. थर्ड, नेग्लिजेंस है. व्हेन द प्लेंटिफ consents to take some risk, the presumption is that the defendant would not be negligent. Rescue cases क्या है? When the plaintiff voluntarily takes a risk to rescue somebody from an imminent danger created by an act or omission of the defendant, he cannot be met with the defense of voluntary non-fit injury. Then we have the case of Haynes versus Harwood. A constable was seriously injured while trying to stop an unmanned wagon moving down a hillock from hitting a woman and a child. VNFI cannot be used as a defense against the constable. Then Baker versus Hopkins का एक केस है. The law cannot penalize the courage of the rescuer by depriving him of any remedy. देखो, अगर कोई रेस्क्यू कर रहा है तो उसको हम डिप्राइव नहीं कर सकते किसी भी रेमेडी से. सो ये सीन है पहला. ठीक है. एक्सेप्शंस मैंने आपको बता दिए. यहाँ मैं छोटे में भी लिख देता हूँ एक्सेप्शंस. रेस्क्यू केसेस, ठीक है. उसके बाद है नेग्लिजेंस. ठीक है. उसके बाद है कंसेंट टू अनलॉफुल एक्ट. Then we have breach of statutory duty. ये चार एक्सेप्शंस है. ठीक है. एक इलॉट वर्सेस विल्स का एक केस है. ठीक है. यहाँ पे मैंने आपको बता दिया है. ट्रेसपासर नोइंग अबाउट प्रेजेंस ऑफ द स्प्रिंग गन्स ऑन लैंड could not recover damages when he was shot by a spring gun. ठीक है. इसमें प्लेंटिफ खुद ही एक रॉन्ग डूअर है. Then there is the concept of inevitable accident. The accident should not have been capable of being prevented by ordinary skill or diligence. नाइट्रोग्लाइसरीन का एक केस है. No one is responsible for unavoidable injuries caused while engaging in lawful business. The measure of care is one that a person of ordinary prudence and caution would use or have used while assuming a similar level of that risk. ठीक है. Then in case of a question paper, take points from negligence and no fault liability, जो मैं negligence में आपको पढ़ाऊंगा अभी. ठीक है. मैं थोड़ा सा ऐड भी कर देता हूँ यहाँ पे आपके लिए. इनएविटेबल एक्सीडेंट में क्या क्या इन्वॉल्व होगा. इनएविटेबल एक्सीडेंट, राइट. Inevitable accident as a exception. ठीक है. First of all, that there is no negligence, and B, not a willful act. This is how the person escapes liability in inevitable accident. ठीक है. The accident should not have been capable of being prevented by ordinary skill or diligence or prudence in the same time as well. विस मेजर का कॉन्सेप्ट को हम पढ़ते हैं. ठीक है. इसमें क्या होनी चाहिए? पहले तो अननेचुरल फोर्सेस, ऑपरेशन ऑफ नेचुरल फोर्सेस विदाउट human intervention. Second, the occurrence must be extraordinary and its consequence must be unforeseeable. ठीक है. ये दो इंपॉर्टेंट एसेंशियल्स है. इसको हमें याद रखना है. केस है निकोल्स वर्सेस मार्शलैंड. Unprecedented runs caused defendant's lake to overflow, washing away bridges constructed by the plaintiff on his property. Hence, defendant was not liable since the loss had occurred due to the act of God. देखिए बारिश act of God ही है. Mahendra Nath versus Mathur Das. Hoarding put by D fell on P due to strong winds. This was a case of pure negligence. Proper care could have been prevented the banner from being blown away by regular monsoon winds. इसमें देखिए अगर आप ढंग से लगाते तो ये प्रिवेंट हो सकता था, लेकिन वो नहीं किया. प्रॉपर डिलीजेंस नहीं रखी गई, नेग्लिजेंस हुआ. इस वजह से इसको जो जो लाइबिलिटी थी वो ठहराई गई टू द पर्सन हु होल्डेड द होल बैनर. ठीक है. देन द कॉन्सेप्ट ऑफ प्राइवेट डिफेंस. प्राइवेट डिफेंस का अब हम कॉन्सेप्ट पढ़ेंगे. द लॉ परमिट्स द यूज ऑफ रीजनेबल फोर्स टू प्रोटेक्ट वंस ओन पर्सन एंड प्रॉपर्टी provided there was an imminent threat. A, the force was not disproportionate, and C, the force was employed only in defensive purposes. ये तीन essentials है कि imminent threat है, disproportionate force का use नहीं है, and it is only for defensive purposes. 3. Then there is the case of Bird versus Holbrook. Fixing the spring guns on the property without any warning sign is disproportionate use of force. Right? Different from Elliot versus Wikes. As plaintiff had knowledge of the guns. यहाँ पे knowledge नहीं थी. But Elliot versus Wikes can be used here at the same time as well. Mistake of law or fact is no defense as an action of tort. However, the wrong malicious prosecution does not arise if D acts under an honest mistake or what belief. नेसेसिटी क्या है? नेसेसिटी का कॉन्सेप्ट भी हम पढ़ते हैं. ठीक है. एक मैक्सिम है, वो मैं लिख देता हूँ यहीं पर ही आप लोगों के लिए. मैक्सिम है सालिस पॉपुलर सुप्रीमा लेक्स. अच्छा ये लिखी हुई है सालिस पॉपुलर सुप्रीमा लेक्स. द गुड ऑफ पीपल इज द सुप्रीम लॉ. द गुड ऑफ पीपल इज द सुप्रीम लॉ. ठीक है. एन एक्ट डन टू प्रिवेंट ग्रेटर इविल इज नॉट एक्शनेबल even if damage was caused intentionally. For example, throwing goods off the board to prevent ship from sinking and saving people. ठीक है. Salus populi suprema lex. The good of people, populi मतलब people, is the supreme law. Suprema lex, lex mentor, law. क्राइटेरिया क्या है? इमिनेंट डेंजर होना चाहिए, लैक ऑफ ऑल्टरनेटिव्स होने चाहिए, एंड देयर शुड बी अ प्रोपोर्शनेट रिस्पॉन्स. राइट. सेकंड लास्ट वी हैव द कॉन्सेप्ट ऑफ स्टैट्यूटरी अथॉरिटी. नो एक्शन can be maintained against an act authorized by the legislature. The person injured by such an act will have no remedy except under the statute itself. This applies not only to obvious harm but also to any incidental harm caused by the plaintiff. Example, if while destroying a wall illegally constructed by the plaintiff, the roof of his house comes down on the wall. ठीक है. ये स्टैट्यूटरी अथॉरिटी के अंतर्गत होता है. देन वॉन वर्सेस स्टाफ व्हेल रेल कंपनी. Sparks from the respondent's engine. Sparks from the respondent's engine set fire on plaintiff's woods on the adjoining land. It was held that since the respondent had taken proper care to prevent emissions of spark, there was no cause of damages as he was statutorily authorized to operate the rail line. स्टैट्यूटरी अथॉरिटी के अंतर्गत ये नुकसान हुआ है तो इसलिए ये एक्सेप्शन होगी, एक डिफेंस होगा एक. राइट. However, the defense of statutory authority does not apply on negligent acts. देखिए डिफेंस में भी एक डिफेंस है जो है नेग्लिजेंट एक्ट्स. एग्जाम्पल, इन द aforementioned case, if the dry grass near the railway line was not trimmed and caught fire due to the sparks, any damage to piece property would have been attributed to D's negligence. और अगर नेग्लिजेंस होती तो ये डिफेंस नहीं लागू किया जाता. रामाचंद्रन मिल्स वर्सेस म्यूनिसिपल कमिश्नर का एक केस है. अ सैनिटरी इंस्पेक्टर at a railway station loaded the seized oil canisters of P into waste handling truck, thereby making oil unfit for consumption. This was a clear case of negligence on the inspector's part, hence D was liable for damages because there was negligence. Then the concept of silent harm. The law does not take account of trifles. De minimis non curat lex. However, the maxim is not applicable where there is harm to one's legal right. अगर legal right होगा तो ये maxim applicable नहीं है. ठीक है. अगर slight harm का concept हो रहा है तब भी एक defense माना जाएगा. ठीक है. So these are a few things which we had to study. Like yes. So this is it for general defenses. Next video we'll study about joint tortfeasors. I hope you like the video. Have a great day ahead. Bye.